All right, I would like to, today it is my pleasure to introduce Jamie Thaxton, our speaker. He is at Caldwell Law, and we are thrilled to have him, and we're very fortunate to have you. And Jamie went to the Vermont, got his degree in law from the Vermont, I'm sorry, my glasses. It's Vermont Law School, right. And then you also, which is interesting, got a Master of Degree in Environmental Law from the same school, which is very interesting. And Jamie's been practicing law in New Hampshire for about 14, let's see, you came to the Caldwell Law in 2000.
Well, 7 years coming up this year, so
7 years.
Yep.
All right, so he's been, even though he lives in Thetford, Vermont, he practices law in New Hampshire at Caldwell Law. And he also is serving on the Planning Commission in the town of Thetford. So Jamie, thank you for your time and your expertise, and we will enjoy listening. Thank you.
Oh, very good. Thank you very much. Yeah, so Caldwell Law, we're a local law firm specializing in estate planning, probate administration, and what is sometimes called elder law. Elder law deals with things like Medicare, Medicaid, and long-term care planning. So I primarily work with Medicaid, getting people qualified for Medicaid. So that is the long-term care government benefit. Medicare would cover things like your hospital visits, your surgery, some acute care, and then they have a cap of up to 100 days where you can get like physical rehabilitation, but then at the end of that time, Medicare will not cover nursing home costs. So if you have a diagnosis of dementia and you are physically very healthy but incapacitated, that you can't make decisions or live on your own and you need a nursing home level of care, then it would be Medicaid if you can't pay for that nursing home privately. So just an overall general overview of long-term care and Medicaid. Medicaid itself was developed 1950s and 60s, and some of those rules have still remained, but this overall federal program is administered by each state individually. So each state has slightly different rules, slightly different way to implement or get the eligibility requirements satisfied. So you have to be very careful about talking about your state-specific rules, and then those rules change over time too. So, you know, it's very difficult to get up-to-date specific information on the web, for example. You need really to get that specific legal advice if you're talking about applying for Medicaid. So in general, there's about, for folks that are over 65 years old, about 65%, I think it is, of folks over 65 will need some nursing home stay in their lifetime. And the average stay in a nursing home is 2.5 years. So over 60%, almost 2/3 of Americans over 65 will need some level of Medicaid care, and then on average that care can last up to 2.5 years. Of course, sometimes people need much longer care, years and years and years of that. Other folks may only need that nursing home level of care for a short period of time, maybe a month or even less. But now each individual state has also expanded this nursing home program, basically the long-term care Medicaid program, to an at-home program as well. So this is the expanded Medicaid that you might hear. And that way they can pay for basically hours per week for a skilled nursing aide to come into your home. The financial and eligibility requirements are still the same, but you do get that care in your home. So we'll talk a bit more about that in just a little bit. But I wanted to give you a quick overview of that Medicaid program. And we will first, however, start off with a discussion about things that Caldwell thinks that everyone should have as far as their estate planning and those documents that are needed to help you if you lose capacity or when you pass away. So I'm going to start sharing my screen now, and I encourage you to jump in if you can with any questions. It's always nice to have questions and talk with folks, but maybe we can do that through that Q&A service or feature. But here we are. So we've talked a little bit about long-term care and Medicaid. So we've got, you could pay privately for your care, right? You pay, you have health insurance that covers a lot of the costs. When you're over 65, you can get Medicare. And then at some point you may need, though, to apply for Medicaid. Now, Medicaid also, to get even more confusing, so there's the long-term care Medicaid, which has nursing home, nursing facility level benefits, and then there's the at-home Medicaid. In New Hampshire, it's called New Choices for Independence. In Vermont, it's called Choices for Care. But then there's also the medical insurance Medicaid, and that's for folks that are indigent, right? That are below the poverty line. Their income is below the poverty line. Sometimes this has been called Obamacare, but this would be for folks that are under 65 years of age, but just don't have income to be able to pay for healthcare, so they can get government-supported healthcare in that situation. We are really talking about long-term care Medicaid, which is primarily designed for nursing facilities. So I'll talk a lot about that. And then there's also this expanded Medicaid for at-home benefits for skilled nursing care. So we think, as I said, everyone should have some basic estate planning documents. And, estate planning would cover things, what happens, while you're alive and well, you're making all those decisions, right? You own your assets, you can buy, sell, transfer, gift, whatever you want to do. You make decisions about your health care all the time. But then when you become incapacitated, right, when it's either physically or mentally incapacitated, you need someone to make those decisions for you. And so that would be when you need to set up those ideas. You're still alive, but you're incapacitated. You need a durable power of attorney for financial matters. So your agent under that powers can pay your bills, access your bank account, do all those regular real estate or investment or taxes related activities. And then they might have extraordinary or special powers that would allow them to do things like make gifts of your assets, change beneficiary forms, or change ownership, which we'll see that it can become important when you're talking about getting approved for Medicaid. And so then basically the final thing is, what are you're trying to give away what you have to whom you want, when you want, and how I want. So, that's, as Tim Caldwell will say here, you can't take it with you. At some point, you're going to be giving away your assets, right? Whether that's through a will or a trust or during your lifetime, that you get to make those decisions now while you have the capacity to do that, and then set it up so it's easier on your agent to take care of those things for you. Now, we use a kind of a general term, the helper, as both the agent under a power of attorney, the executor under your will, or a trustee under your trust. So these kind of general terms we just group together as a helper. So we want to make sure that folks who do estate planning with us understand their estate plan. This first question. So many folks that we talk to will come in and say, I have a trust or I have a will, but I don't know what it says. I don't know how it works. So we may put a strong emphasis on education. That's why we do a series every month. We do the truth about estate planning. Every other month, I do a long-term care and Medicaid planning workshop. Throughout the year, we have other lunch and learn type activities at Caldwell Law. So we really do put an emphasis on estate planning, understanding your plan, and we want to make sure that everyone can answer yes to that basic question. Now, of course, if you understand it, you also want to make sure that it has a positive impact. It benefits you, right? It's meeting your goals, doing what you want it to do. So sometimes we'll have something that will say, well, if you took the standard form off the internet and you filled it out on your own, maybe it doesn't cover all those things that you needed to cover if you had talked with an attorney and got it specified for your particular situation. So we want to make sure that it works and it works well and you understand it. And then we spend a lot of time on this third one. Are my assets titled in a manner that's consistent with my plan? So asset ownership becomes very important. We'll talk about how maybe having a joint title with rights to survivorship will actually trump the will, right? It will be that property will go outside of the will, or with something with a beneficiary designation on it, like life insurance or an IRA. That happens outside the will. So because of the way it's owned, the way it's titled, it will affect your estate plan. And so some, law firms may say, okay, we'll prepare a trust for you, we'll prepare your will, but it's up to you to go put maybe title into your trust if you're trying to avoid probate, or change title to make sure that, you have beneficiaries for your IRAs or something like that. So asset title, asset ownership is very important, and we'll talk about that a bit more. And then finally, do my helpers understand their responsibilities? They have to know what to do. If we don't want to surprise folks, if they're going to be your healthcare agent, you should have a conversation with them about what you're expecting for your life-sustaining treatment and those difficult situations, so that they know what to do when and if the time comes. So as I said, we think everyone should have this financial power of attorney, right? The standard allows your agent, if you are incapacitated, actually it could be either. So when it's effective, could be either immediately or only upon your determination of incapacity by a doctor or two doctors. Usually we'll say, we see a lot where it says, I'm going to make it immediately effective for my spouse, right? My spouse could walk into the bank with the power of attorney. Even if I have capacity, I'm still out there working and doing all the other things I do. She could be able to go in and say, all right, I need to get access to this bank account that's only in Jamie's name. Otherwise, you could say, no, this durable power of attorney only is effective when I become incapacitated. So the spouse might have it immediately, but the next person in line, maybe it's a child, maybe it's a friend or family member, it would be only effective when you become incapacitated. So there is an ability basically to control who would have that access, but you want to have that set up. If you didn't have a financial power of attorney, there was nothing in place, you become incapacitated. So as Tim says again here, if you hit the moose, right, you're out driving and hit the moose and become incapacitated, you need long-term care, you need nursing home level of care, you need your agent already in place, ready to step into your shoes and be able to pay your bills and do all that planning and maybe apply for Medicaid on your behalf. So if you did not have that financial power of attorney, you would be in the situation where someone needs to apply to the probate court and get guardianship over you. So the probate court would award the person powers as guardian over your finances and over your health care, likely too. So that guardianship process does take time, and it takes some expense, and it will often be something that will cause a lot of stress for your people that are trying to help you out. So better to have this financial power of attorney in place. It's durable, meaning it lasts after you lose your capacity to make those decisions, and it gives their agent a broad variety of powers that they can do on your behalf, right? It's all on your behalf in your best interest. They can't, take out money and use it on themselves without, being in your best interest. So while we hear some stories of folks, acting poorly and not abusing that authority when they're acting as agent under a power of attorney, that is against the law, right? That is fraudulent. They're not allowed to do that. The vast majority of cases, almost all cases, your agent is acting in your best interest and trying to help you by making these decisions when you cannot. So similar to the financial power of attorney, the healthcare power of attorney, some people call it the advance directive. And this is the one that says, if I'm unconscious, not able to recover, and I don't want life-sustaining treatment to be started, or if it's already started, to be stopped. It gives your agent that authority to basically stop treatment if you have been determined, with a permanently disabled, permanently unconscious, close to death, that kind of thing. So really the doctor is in charge of that, and they'll say, okay, we've made the decision now. This is when the advance directive is going to be invoked. What agent do you want me to do here? So it really is a partnership with the doctor, but it's important to get those, your preferences known to your agent so that they know if that decision had to be made what you're thinking about. So we encourage folks to update these documents regularly. If you have a healthcare power of attorney that's 10, 15 years old, your agent may be questioning, well, do they still feel like that? I'm not sure if I'm making the right decision, or if it's something that was only a year or two old, they'd feel much more confident, be able to make those decisions much better. So both financial power of attorney and healthcare power of attorney, important documents for every estate plan. So the problem with long-term care, right, is that it's expensive. Nursing homes in our area probably go between $10,000 and $12,000 a month. So you can do the math and think about how much you have in savings and how quickly that would be all spent down if you had to pay that nursing home cost month to month to month. Some are less expensive in our area. We might see some that are $8,000 a month. They can go up even greater, and then some are, basically not, they don't accept Medicaid, so it's not something that you would be able to get that Medicaid benefit for. But self-insuring, right? So you have enough investment, you have enough savings, you have enough income to be able to pay that cost for nursing home level of care without dipping into your savings. So, you would have to have millions of dollars essentially to be able to generate $10,000, $12,000 a month to pay for your care in a nursing home. But if you can do that, great. Then, you don't really need to worry about applying for Medicaid in the future. You are self-insured. But, you start doing the math here and you say, well, what if it was, if you're married, what if it's both of us need nursing home level of care? And then you're talking $25,000 a month. And could you really expect to have that income coming in at that level? Otherwise, another option you might consider is long-term care insurance. So long-term care insurance, they provide a variety of benefits. And basically what's happened with this is that in the past, they had very expensive coverage that was basically unlimited. So it says, if you need nursing home level of care and you pay the premiums, we will cover that care at the nursing home. Well, the cost just became prohibitive. People were living longer and they were needing more and more benefits, and the premiums kept going up and up and up and up. So no one was buying it anymore. And so the life insurance companies, the long-term care insurance companies stopped doing that. So they were saying, okay, we need new products. And basically what they've done now is limit the amount of the payout per day and the length of time that it will last. So typically what we see is about 2 to 3 years of coverage and paying out about $200, $250 a day. That would be about $6,000 a month. So that would not cover the full amount of the private pay at a nursing home in our area. You would have to supplement that with your income, with your savings in order to get up to that private pay amount. Although just the other day, I saw someone had a policy that paid out something like that, $437 a day. So that would be $16,000 a month. So they were covered. They were going to have full coverage of their nursing home costs. And that lasted for 3 years. So that's a very strong coverage and basically would allow them to avoid Medicaid and maybe not have to do that Medicaid planning that some other folks have to do. Another thing that we want to look out for is the elimination period. Many times this will be similar to what the Medicare elimination period is that they say you will need to pay privately for your care for 100 days before the long-term care insurance benefit starts. And that 100 days, remember, is the Medicare period of time they would pay for the long-term care or nursing home benefits. So basically they say you have to use up your Medicare benefits first, and then long-term care insurance would start. And then there's other things here too that you want to look out for, but another one is inflation protection. Hopefully that will grow, over time. So maybe you get 5% inflation or 5% benefit that will keep growing and growing. Other things that they've done now are other types of long-term care insurance products. One is called the hybrid insurance policy, where it's a life insurance policy, but if you need to get access to that benefit during your lifetime for a nursing home benefit, that you can do that. So it's not one of those use it or lose it, right? In the past, it was, I had paid my premiums on my long-term care insurance for years and years and years, and I never needed it. then it goes away and you don't get a benefit out of it. Now this would say, okay, if you don't need long-term care insurance benefits, then it will go in the form of a life insurance benefit to your beneficiaries. So that's a good thing to look into. If you do have life insurance already, you might ask about a long-term care insurance rider on that policy where you could get access to it. Another product they're doing is called the single premium insurance, long-term care insurance policy. And so you'll say, instead of paying a bunch of premiums over time, you'll say one large premium. So $100,000 long-term care insurance, that will immediately result in a higher benefit than just the $100,000. So if you needed long-term care insurance right away, you get $150,000 worth of benefit, and it grows over time too. So that can be a good option for folks. That may be something in between some of the more permanent or advanced long-term care planning techniques that we use. But basically take a chunk of savings, say, okay, we're going to put this in a long-term care insurance policy. You get good benefits out of it. It grows over time. And so it will be something that will be there in case you need it. Okay, so we'll, when do the long-term care insurance start? They will talk about activities of daily living. This is something that we'll come back to again with Medicaid, but basically if you need assistance with these types of activities, bathing, a shower, dressing, eating, feeding, that sort of thing, then you would qualify because you need assistance with activities of daily living. We see that long-term care insurance usually requires 2 of these. And so it might be something that you actually have to have, the diagnosis, to talk to the doctor or the nurse, or get some written statement about you're needing these assistance. Other times, you look very closely at these long-term care insurance policies, they may say something like, this policy only benefits begin when you go directly from the hospital to the nursing facility. And so if you go home and in the meantime, and then decide, no, I really do need that nursing home level of care, then it would not start. So not seeing that too often recently, but in the past, it might have been something to look out for, basically a way that they could deny benefits and say, no, this is only available when you come out of the hospital directly to the nursing facility. So these, the terms of these different policies are important, and usually you would be talking to your life insurance broker or insurance broker about what kind of long-term care insurance might be available. Okay, as we quickly mentioned, Medicare does not cover the cost of long-term care, custodial care. So that's, again, people that have dementia, the classic example, Alzheimer's, would say that although maybe physically they're pretty healthy, mentally they need that high level of care. And so they need that custodial care, right? There's no cure for Alzheimer's yet. So this is not something that we can see that they would be getting better. Although there are some drugs that have just come out onto the, or been approved by the FDA that might have some promise for folks that are in that first level of the mild dementia, being able to keep the symptoms from getting worse, but still we're not at that point yet where we have the ability to cure some of these forms of dementia. And it could be anything else too. I mean, there's many forms of dementia, many diseases that would require nursing home level of care, and it may be something that would qualify for Medicaid. So skilled care too, also we're talking about skilled nursing care. So it's not something that you could, have Medicaid pay for a home companion or, cleaning services or, someone to take you out to go shopping or something like that. This is care under the supervision of a doctor. So if you are getting that at-home Medicaid program, that would only be for those things that the doctor had directed for. But then again, they might assist you with things like cooking or remembering to take your medication and that sort of thing. So it is limited in that way, but that skilled nursing care, that would be something that would be part of that nursing home, nursing facility level of care. Okay. All right, Medicaid. So as I said, I deal with this a lot, but basically the rule is that when you have almost nothing left, you can get this long-term care government benefit that would pay for your nursing facility, pay for your at-home skilled nursing care. It's called the payer of last resort because it's not really an insurance policy. It's saying that they will reimburse the provider for the care they provide, for the healthcare they provide, but they don't they don't reimburse up to that private pay rate, right? So if it's costing privately $10,000 to $12,000 a month, the state government says, the state Medicaid office says, no, we're only going to pay you $6,000 a month. So it's a smaller amount than the private pay rate. And so that's why a lot of facilities say, we can't really handle this. You know, we can't have 100% of our patients, our residents be Medicaid recipients. Otherwise, we wouldn't have enough money to stay in business, pay our staff, and do all the rest of it. So many places in our area will say that they want to have you pay privately for at least 2 years before they would accept you as a Medicaid patient. Now, technically, the rule is if you are impoverished, you don't have money left to pay privately, the facility must keep you there and accept Medicaid reimbursement. However, they will try to get out of it by doing some things. Let's say maybe you need a higher level of care than they can provide, so you have to go to a different facility, one that accepts Medicaid. So it can be a little bit tricky to navigate through that system of private pay and then transitioning to Medicaid. But essentially, this is the only long-term care benefit program in the United States. And so Medicaid becomes important for a lot of people. Now, their first off is this clinical eligibility. So there's two, financial eligibility and clinical eligibility. Clinical eligibility is usually a low bar. They need at least one activity of daily living. Also, that could also be severe cognitive or behavioral issues. So typically they will, as part of the application, will contact the doctor or contact a nurse and say, ask them what level of care that you might need. And on a rare occasion, they might say, well, they're really functioning fine and they can do all these activities of daily living. They just are being forgetful and needing some help, but it doesn't raise that level of clinical eligibility. But however, the states this is a large part, Medicaid is often a large portion of their budget. And when they're trying to cut budget items, the only way they can do this as far as Medicaid is concerned is to make it more difficult to get started in the first place. Because once you started, then it becomes a right that you have to that benefit and they can't stop it at that point. So they try to stop it from starting in the first place. And they make that, and it could come down to that clinical eligibility to make it more rigorous for you to qualify under that clinical eligibility requirement. So the clinical eligibility and then financial eligibility. And I'm going to stop my share just for a second here. I hope that everyone is staying with me. I'm trying to go quickly here so that we have an opportunity to cover everything in a shorter period of time. But basically what I'd like to do is share this chart of basic Medicaid eligibility rules. And here it is. This is for 2022. Basic rule in Vermont, you can only have $2,000 in countable assets, and in New Hampshire, it's $2,500. So a tiny, tiny amount. Now, the key here is countable, though, right? Countable assets. So bank accounts, stocks, bonds, anything really liquid asset that you have would be countable. However, there are lots of non-countable things, and we'll go over those in just a minute. And that's usually the way where people come to Caldwell Law or other long-term care elder law type law firms would be to try to maybe switch an asset from being countable to non-countable, or to speed up eligibility. And so you're not paying as much privately to the nursing home, and instead Medicaid is paying those bills. So they will also look at the married couple. They will say that the well spouse, the community spouse, the spouse in the community, the healthy spouse, whatever you want to call them, they can only keep up to $137,400 of countable assets. And so what they do is they'll look back through your financial records and try to determine, how much altogether you have that are countable assets, and then if you've been giving these assets away. So they don't want you to give your assets away in order to qualify for Medicaid. And we'll talk about that a little bit. So Vermont makes this a little bit easier. They just say 137,400 for the well spouse, period. But in New Hampshire, they said you actually have to spend it down to that amount. So you would have to start out with $274,800 in New Hampshire, spend down $137,400 on your care, and then the well spouse could keep that $137,400. So if you started with less, you would go down, you'd spend down half of it, but there's a minimum level of $27,480. So that married couple in New Hampshire, there is a spend down requirement for what the well spouse or the community spouse can keep. Now, income isn't counted as an asset, so you can have income. The problem is that if you have so much income that you are actually over the Medicaid reimbursement amount, Medicaid will say there's no, we're not providing a benefit. If you are making more than $6,000, for example, per month, they'll say, well, that's the maximum amount we would pay to this facility, so there's no benefit, we're not paying out anything. So in effect, there is an income limit, but it varies by the reimbursement rate for the facility. So some folks can actually get stuck in a situation where they have too much income, but not enough to pay full private pay rate. So if you have $8,000 a month or just over $6,000 a month, and the private pay rate is $10,000, what's going to happen? You can't get Medicaid benefits and you can't pay privately. You'll just probably be accumulating that debt. And so that would be something that you would have to go through and maybe have come out of your, what goes through your estate after you pass away. But in essence, this is what happens. You pay over your income to the nursing facility, whatever income you have, Social Security, IRA distributions, pension, whatever the income is, total it all together. You pay the nursing facility, and then Medicaid puts in the rest up to their reimbursement rate. So if you have $2,000 a month coming in every month, when you get qualified for Medicaid, that $2,000 a month goes to the nursing home, and then Medicaid puts in the next $4,000 to get up to the $6,000 reimbursement rate. So month to month, you're staying below that $2,000 or $2,500 asset limit because the money comes in and then it goes out. And so the next month, you're back starting at $2,000 or $2,500. But you do get to keep $72.66 in Vermont and $74 in New Hampshire as a personal needs allowance. This is often used for haircuts, but it would be also something you could do, candy bars or magazines or whatever it might be. That's your personal needs allowance. So again, a very small amount, but it can be important to plan for. And then some folks, with their room and board and their medical care taken care of, they really don't have any expenses, and so it actually could be something that accumulates over time and puts you over that $2,000 or $2,500 limit. Again, we've got the rules about what happens when the Medicaid spouse has more income than the at-home spouse or the well spouse. And there is a program or a formula to transfer some of that income to the well spouse to be able to pay for their needs, their living costs, essentially. So we get into this minimum monthly needs allowance, the MIMNA, and that can be an important calculation that we do about how to transfer more income to the spouse that's staying at home. So those are some basic rules. There are more, of course, that would be applied to individual situations about assets and income. But I'll go back to sharing the outline now. And let's see if I can get this one pulled up, and it's disappeared on me. Hold on one second. Okay. Oh, there it is. Is that it? Yeah, there it is. Okay, good. So we're back here. We've looked at the chart, financial eligibility. We talked about a little bit about this, but I also mentioned this idea of gifting and the fact that they don't want you to give away your assets in order to qualify for Medicaid. So they do that by looking through 5 years of your financial records, any financial records, IRAs, bank accounts, anything like that. They would want that record, and they will look through it for transfers primarily to individuals, right? So they're saying, hey, 4.5 years ago, you wrote a check for $500 to this individual. Was that a gift? Was that for your benefit? And you say, no, that was, for some landscaping work that we had done. Okay, well, now we want to see, then Medicaid would come back and say, now we want to see a receipt or an invoice or a bill. And this can be a problem. You're scrambling around trying to find things that happened years ago. But essentially, if you had made a gift, they would calculate a penalty period. And so they take the amount of the gift, divide it by the average cost of the nursing homes in the state. That's that state penalty divisor amount. They set it every year. So both for New Hampshire, it's right around $10,000. I think in New Hampshire, it's $10,400 and something, $80. So if you gave away $100,000, divide it roughly by $10,000, that would be 10 months where you would not be able to receive Medicaid. You would be in the penalty period. Now, the problem is that for that 10-month penalty period to start running, you have to be otherwise qualified, meaning you have to be below that $2,000 or $2,500 asset limit. So how do you pay for your nursing home care when you're in the penalty period? And that is a difficulty. I mean, that can be a real problem. But sometimes we can use these rules to our advantage to actually speed up Medicaid eligibility. So if you had $200,000, say, you're $200,000 over the asset limit, you give away $100,000 knowing that it'll cause a 10-month penalty period. But with the other $100,000, you make a loan or you purchase a Medicaid compliant annuity that would pay out $10,000 a month for 10 months. And so that pays your medical care, your nursing home care. So $100,000 in gift, that's the kid's inheritance, that's whatever it is, it's a gift, they get their inheritance early, and then at the end of 10 months, your Medicaid benefits started. So you've actually sped up, instead of paying 20 months, $200,000 on the nursing home, you've only had to pay for 10 months, and you've been able to make that gift. So that's sometimes called the gift and loan strategy. We often use a loan with that. So gift and loan, or the half loaf. I like the half loaf. It's like you can't give away the whole inheritance. You can't do the whole thing, but you can do half of it. And then sometimes we might be able to even do better than that if we do something like that at-home Medicaid program. So then you're paying even less per month, right, for your care. So you could make a larger gift, have a longer penalty period, make a loan for a smaller amount. It pays out that smaller monthly amount month to month, and you get through the penalty period. Instead of doing the half loaf, it becomes the 3/4 loaf. So it's an interesting way. We're just looking at the rules and we're saying, okay, this is something we can do. It's done in all 50 states. And it also emphasizes the need for a strong financial power of attorney, right? So if you're incapacitated and your agent is doing this on your behalf, you will want your agent to be able to have that gifting authority, the authority to make gifts of your assets while you're incapacitated. So while some folks look at it and say, why would I want my agent to be able to give away my money? Well, this could be Medicaid planning. This could be a good strategy for speeding up Medicaid eligibility. So you do want your agent to have that gifting authority. You may want to have them be able to change beneficiary designations and that sort of thing. Those are special or extraordinary powers, and they have to be specifically written into the power of attorney, and they're not something that it would be in what's called a general durable power of attorney, where it does that normal, paying debts, transferring bank accounts, paying for real estate, taxes, that sort of thing. So an important strategy for speeding up Medicaid eligibility. So as I said, that starts when the applicant is otherwise eligible. So we have to get everything lined up, and then the penalty period will start. And then sometimes we're just waiting through that. Meanwhile, this loan or annuity amount is coming in to pay for your care during that time. So this gets us to a question about what is countable and non-countable assets. So the big one for non-countable assets. So this is when you're applying for Medicaid, you've got money in the bank, you've got your home, you've got some other assets, car, some other things. What would be counted that goes to that $2,000 or $2,500 limit? The first one that's not countable, likely the largest one, will be your residence. where you live, that value is not counted. There is a cap on it. It's up to $634,000, I think, in equity value in your home. And then that value would not be counted. Other things that are not counted would be one vehicle in your name, personal property like your furniture, jewelry, clothing, artwork, that sort of thing. Personal property is not countable. Income producing property is not counted. So an apartment, I think that was originally designed to be for farm properties, but we've had folks that maybe have like a second home or a camp property that will be counted, right? Then it's only the residence that's not counted, but the camp would be counted. However, if you rent it out and it's income producing, then the value of that camp or second home may not be counted. However, there might be available for a Medicaid estate recovery lien, where they put a lien on the property for the value of the Medicaid benefits you received during your lifetime. But we'll talk about that in a little bit. So there is the possibility of a lien, but it might be possible to convert maybe a secondary residence or a camp property into income producing property, which would not be counted. Other things, as I mentioned, maybe this Medicaid compliant annuity would not be counted. So you've got a $200,000 brokerage account, savings account, and you put it into a special annuity that would pay out as income, and it's irrevocable. You can't get at the principal. And then Medicaid says, okay, well, that's income now. It's not a countable bank account or brokerage account, savings account. There are some strings attached to this, though. So a Medicaid compliant annuity, one of the big ones is that you would have to put the state of that, the state of New Hampshire, the state of Vermont as the primary beneficiary up to the amount that you've actually received in Medicaid benefits during your lifetime. So they will say, okay, if we are put in as the first beneficiary and you've got this $200,000 annuity and it's paying out during your lifetime, whatever it is, $5,000 a month, keeps coming in, and then you pass away having received Medicaid benefits, they total up all of your benefits during your lifetime. They say, okay, we've got $30,000 of Medicaid benefits were paid out, and they look at what's remaining on the Medicaid compliant annuity, and they say, well, you still have $100,000 in benefit, so that $30,000 goes to pay the state for their Medicaid reimbursement, and then the remaining $70,000 goes to your secondary beneficiaries, who may be the kids or something like that. So Medicaid compliant annuities can be an important way to convert a countable asset into a non-countable stream of income. Other non-countable assets would be a burial or a funeral fund up to $10,000 per individual. So it's always a good idea to go ahead and prepay that funeral. Usually folks will just go right to the funeral home and basically get a bill, pay it off, and then that's an asset, but it's not counted for Medicaid purposes. And then we come to IRAs. IRAs in Vermont would not be countable. Period, end of story. They just said if it's in the payout phase, we're not going to count the value, the principal value of the IRA. However, in New Hampshire, they do want you to put the state as the primary beneficiary on that IRA, similar to the Medicaid compliant annuities. So it's a little bit more difficult in New Hampshire, but it is something that we're seeing. We just say, okay, this is it. This is what they have in IRA. It's in the payout phase. And sometimes they've said, okay, we're not going to count that. So IRAs, good assets to have, keep those going. If possible, they could be a non-countable asset and get you Medicaid benefits started more quickly. So I mentioned a couple times already, different strategies we can have to convert countable to non-countable assets. So for example, this savings account, you've got $100,000 in your savings account, and you know that your residence is not counted. So maybe there's some deferred maintenance there, right? Or something that needs to be done. You could take money and invest it, your savings, and invest it in your residence. Put the new roof on, put the ramp on, remodel the bathroom so it's handicap accessible, whatever it is. You're taking that countable savings account, putting it into the non-countable asset. you get the benefit of having the nicer home and more safe or comfortable house. And you can also qualify for Medicaid more quickly. So that's sort of a kind of a nice or a beneficial way to convert countable to non-countable. But you also might be able to do something, like I said, purchase a Medicaid compliant annuity, make a private loan, right? So you're increasing your income. It's not a gift, it's a loan. Or any transfer that happened beyond the 5-year look back, there would be no penalty period there. So sometimes we're talking about people who are trying to protect assets by putting them into an irrevocable trust. And we'll talk about trust in just a minute, but that could be a gift. So as if you get 5 years and 1 day beyond the look back period, then there's no gifting penalty, there's no penalty period. Okay, so there are some exceptions to those gifting rules, exempt transfers. Big one is a house can be transferred to their spouse or a child who's permanently disabled under 21. And the one that we see sometimes can be applicable, a child who's resided in the home and provided care to the applicant for 2 years prior to the application. So that would be the child caregiver exception. Not, obviously it's very situation dependent, but it could be an important one. Any other assets may be transferred to a spouse. So we will often separate folks' bank accounts to have income for the institutionalized or the Medicaid spouse in one bank account, and the at-home or the well spouse in another account. That way the income going to the Medicaid recipient spouse can go into their bank account and then go out. Meanwhile, the at-home spouse can actually accumulate assets. It can go over that $137,000 limit once the Medicaid spouse has been approved and starts receiving benefits. So that can be an important one we do with spouses, or to a disabled child or trust, or to a supplemental needs trust. We'll talk a little bit about more supplemental needs trusts in just a minute. I mentioned the idea of estate recovery. This is this lien on your property. Usually it relates only to real estate, right? Because if you only have $2,000 or $2,500 left, there's nothing to recover against. So it's only in that situation where you die owning your own home in your name, having received Medicaid benefits. If it's jointly owned, right, you've got a surviving spouse, no lien in that situation, so no lien. So it's really only certain situations that we'd have to look out for, and one of those is where you have one spouse who passes away, the surviving spouse then needs Medicaid, the house is still in their own name, they can't give it away, they can't transfer it, so they have to accept that lien, and then when they pass away, typically what happens would be the beneficiaries, the kids, would sell the house, pay off the lien, and then split the proceeds as their inheritance. So New Hampshire, Vermont will only go after probate assets, but New Hampshire will go after assets that transfer outside of probate. And so sometimes we'll have a life estate problem that would be there. In Vermont, again, there's the enhanced life estate deed, also called the Ladybird deed, which will avoid that Medicaid lien. So we do those enhanced life estate deeds regularly for properties in Vermont. Okay, we're going quickly here. Thanks again. Now we're going to annuities. We've talked a bit about this. So as I mentioned, the state is named as primary beneficiary. They're irrevocable. They have to be paid back within your life expectancy. So the Social Security sets up a life expectancy table. That can be a problem if we've got a large amount. You've got the $200,000 savings account. You've got your Medicaid compliant annuity, but you're 100 years old. In that case, you only have a 2-year life expectancy. That $200,000 would have to pay out $100,000 a year. That would be way more than the reimbursement rate, so you wouldn't get a Medicaid benefit. So we do have to worry a little bit about how much income is coming in, and sometimes we want to stretch it out so there's a smaller amount coming in. Other times we want to speed it up so the Medicaid compliant annuity doesn't last very long. And sometimes we do that with a community spouse or the well spouse, so they can get their money out of that annuity quickly. Okay, so then I mentioned trust. Now, the regular revocable trust, right, is going to be counted. Anything in a term, in a revocable trust, even your residence, the value of your residence, if it's in the name of the revocable trust, will be counted. So sometimes we're in the situation where you actually have to take title out of the revocable trust, put it back into the individual's own name in order for that Medicaid application to be approved. Now we can do an irrevocable trust. So essentially with that, you are giving up ownership of that asset. You cannot be the trustee of your own irrevocable trust and not have it be accountable for Medicaid. So a lot of times we're seeing the children be the trustees of this trust for the benefit of the Medicaid person. And so what would happen is say, okay, the trustees have full absolute discretion to make a distribution or not. You don't have a right to any of those assets in the irrevocable trust, but it would be something, hey, the house needs a new roof. Why don't you use money from the irrevocable trust to pay for the new roof? My kids are happy to do that. They write the check, and it's pretty straightforward. We do have to worry about that 5-year look back rule. So any amount that you put into the irrevocable trust would be considered a gift and could cause a penalty period. But for those folks that are in the right situation, maybe they have long-term care insurance, they've got enough assets, they could get through that 5-year look back period. They will say, okay, let's set up the irrevocable trust now, or we'll make that transfer, we'll hope for the best, we'll try to avoid the moose. And then at the end of 5 years, one day, there's no penalty period. They can apply for Medicaid, get qualified right away, and then that irrevocable trust fund would be available for their benefit. So something to think about in that we kind of break that down into that long-term care planning. You may be able to get beyond 5 years, or the crisis Medicaid application. We do both of those. Someone calls in and says, parents are going into the nursing home next week. Is there anything we can do to speed up Medicaid eligibility? And say, sure, maybe we can do this half loaf strategy. Maybe we need to retitle some of their assets. And then instead of paying the $10,000 a month until there's nothing left, speed up Medicaid eligibility, and you get some of those nice benefits by doing that long-term care planning. Also, another thing to consider would be for maybe the at-home or well spouse, create a trust under your will. So a typical will would say, everything goes to my spouse outright if I die. But if they're Medicaid, if your spouse is receiving Medicaid, and you happen to pass away first, then that inheritance will be a countable asset. They would have to spend through that asset in order to restart Medicaid benefits. And so maybe instead of that, you create a trust in your will. So the will is not created during your lifetime, but when you pass away, when you die, the will goes to probate. The probate court creates the supplemental needs trust, so you could supplement the Medicaid benefits of the Medicaid recipient spouse, and it would likely, be there to be available for your beneficiaries after that Medicaid spouse passes away. So it can be a good tool and something that would be something that you might want to change your estate plan if you had that diagnosis of a long-term care disease, or you knew that a Medicaid application was likely in your future. Okay, good, thanks. I think we got through it. So remember that there's all sorts of things that could happen to change your estate planning, long-term care planning, changes in personal situation, your financial situation, legal environment. As I said, Medicaid rules change all the time. There is a proposal in Congress now to do away with the Medicaid estate recovery lien altogether. So it is something that maybe those rules will change, although we haven't seen that go forward yet. Changes in our experience, there's been a lot of changes with COVID, I'll tell you that right now. They haven't been able to get all the workers they need, of course, and you put in these applications and the folks are brand new, they don't know the rules themselves, so we have to tell them things, and it's like the IRA situation. We will sometimes just spread it out and say, okay, this is all their assets, and they'll say, okay, you get approved, and we'll say, that was interesting, that wasn't the exact same experience we had last time, but yes, okay, we'll go forward from there. So changes in experience, and then your experience. A lot of folks come to us and they say, oh, I had to get my parents qualified for Medicaid. It was a nightmare. We want to hire you guys to take care of it for us. Other folks are saying, I really want to avoid probate, or I've got this special family situation that we're trying to deal with. So, all those things can influence your estate planning. In order to be able to respond more quickly and have make sure your plan works, we've got Caldwell Law does a life plan program. It's an update program and maintenance program to make sure that your estate plan is working properly. Otherwise, a lot of our clients are traditional. We set you up with the plan, get everything in place, you go on your way. Then if something changes, you need something, something changed in your estate plan, give us a call. We'll be happy to help out. Those are our traditional clients. So I hope, you don't get the evaluation here, but please feel free to contact Caldwell Law to set up a meeting or learn more. Also, our website has a bunch of useful information on it, estateandelderlawgroup.com, or you can Google Caldwell Law and look for estateandelderlawgroup.com. There is a resources section in our website where you can get a blank financial power of attorney form, a blank healthcare advance directive form, other papers and information regarding estate planning. So it is a good resource, and I encourage you to go there. Otherwise, of course, I would be happy to get an email, or you can do our info at estateandelderlawgroup.com for more information or to get started. I really appreciate everyone being here today, and I know it's kind of tough, as some people say, it's like drinking from the fire hose, right? You got a lot of new information, you catch what you can, but it helps to get more familiar with the terms, and then you're ready to be prepared when the time comes. So thanks again, and I really appreciate it. Did we have any questions? Anyone have any questions come in?
We don't have any that came in.
All right. I was speaking so fast, I'm sure you're just sitting in the back of their chair.
You had a lot of information. Thank you.
Yeah.
David, do you have a question?
All right.
So we'll give people just 1 second. If you have a question at this point, you can put it in the Q&A and we will give it to Jamie.
Jamie, I might ask, a lot of people in the Eastman community have made some plans for their future. A lot of those involve in-home care. And I'm just wondering, not from a financial point of view, but in terms of is it really, how much of a difficulty is it in the Upper Valley today to have quality in-home care? To actually get people to do it?
We definitely got stressed during the COVID and process here, the COVID experience. There weren't many folks that were willing to do that at-home care. If you could get paid $60 an hour by being a visiting nurse or something and go to the hospital, that was a much better deal than going into a home and getting $20, $25 an hour or something like that. So there has been a real shortage. And actually, the state of New Hampshire Medicaid office is being sued by AARP right now because they have not been able to provide all the at-home Medicaid services that they are required by law to provide. And so I'm hopeful that lawsuit will result in higher reimbursement rates and more training being offered. But we are lucky to be here in this Dartmouth, Hitchcock health area, Visiting Nurses Association, different private caregiver agencies, organizations. And so really they have been doing a fairly good job of being able to fill these positions. And so in some cases, I'm telling folks, yes, go ahead, hire that agency. If you need the care in your home, go ahead and start that. You can pay privately at first. Maybe it's a small amount to begin with. Then you're on the list. And then if you need to transition to Medicaid, at least you've got that relationship established. And so, that's more likely that you would be carrying on. But yeah, it's kind of a mixed bag, but I do think that we've got at least a good, strong program, a lot of, different agencies, options for folks to get that in-home care. And so something to think about, and maybe, as I said, get on the list, start receiving that care, even if it's just, 4 hours a week or something like that. If you need it, go ahead and use it. But yeah, it's interesting. We've got Dartmouth has had a real commitment to training folks and getting the workers that they need. So we really kind of are a beneficiary of all that here in this area, which again makes it more attractive. We're getting more and more folks, and so it's become a real retirement area. Hopefully those services will be difficult to obtain, but yeah, for a while there it was really kind of difficult. And I had one client that was way up on the Canadian border, and they were saying that Medicaid at home is not an option. They would never be able to get someone to drive all the way up there. So it does kind of relate to your personal situation. But yeah, luckily we've had most of the folks that I've talked to have had good success with getting care at their home, in their home.
That's good.
Yep.
Anything else? All right. Well, thank you, Jamie, so very much for taking the time. And there was a lot of information and we really, really appreciate it.
Oh, you're quite welcome. Thanks again. Thanks for setting this up.
Okay. And thank you, everybody, for joining us today. We'll see you in November.
Bye.
Bye.
Thank you.